Superior Court of Justice has reinstated a regulation to cap the number of migrant workers who can occupy a bunkhouse during their mandatory 14-day quarantine at 3. Back in March, the medical officer of health for Northbrook County said no bunkhouse or house trailer used on a farm for quarantine purposes can accommodate more than 3 migrant workers for a mandatory 14-day quarantine duration. In June, a farmer in Simcoe County challenged that order, saying the province's quarantine requirements do not include the 3-person cap on bunkhouses during the mandatory 2-week quarantine. The court ruled in the farmer's favor, but the medical officer of health appealed that reversal in July. Advocates for migrant workers welcome today's decision by the Superior Court of Justice, but say it's only a small step towards protecting migrant workers.
Definitely more needs to be done. I mean, Justicia has always called for status now upon arrival for migrant workers, because really that's the only solution to solve all of the issues that they face when coming to Canada. At the very least, right now, we're calling upon other jurisdictions to implement the same type of an order, not just for the first 14-day period, but thereafter.
A coalition supporting migrant workers has come up with a number of recommendations moving forward that include the Chief Medical Officer of Ontario must implement the 3-person to a bunkhouse rule across the province. Ontario must also take responsibility to cover the costs during the quarantine period, and workers must be granted permanent resident status upon arrival. We reached out to Brett Schruler, the farmer who challenged the initial order, for his response to today's decision. He has issued a statement saying, quote, although the decision is disappointing, the support shown from the public has been absolutely overwhelming. From day one, this appeal has been about food security and protecting workers' health and rights.